Thank you for coming before the committee. We appreciate you taking the time to speak to the committee and look forward to hearing from you today. This is a formal proceeding of the committee, and the protections of parliamentary privilege and the obligation not to mislead the committee apply. This is a public hearing and is being webcast through the Assembly's website. A transcript will be made for use of the committee and may be put on the committee's website. If at any time during the hearing you are concerned that what you will say should not be made public, you may ask the committee to go into a closed session and take your evidence in private. Can you each please state your name and the capacity in which you are appearing?
Thanks very much. Thanks very much, Deputy Chair. My name's Alister. I'm the Chief Executive of the Department of Mining and Energy.
James Pratt, Senior Executive Director of Energy Development.
Easton, Director of Policy and Reform, Department of Mining and Energy.
Yeah. Yes, turned it. Red light means on. But it should be all good. Thank you. Before we begin, I'd like to introduce my fellow committee members. We have the member for Gwoja, Mr. Chansey Paech, the member for Drysdale, Mr. Clinton Howe, the member for Johnston, Justine Davis, and joining us via teleconferencing is Miss Ollie Carlson, the member for Wanguri, and I'm Andrew Mackay, the member for Goyder. Mr. Trier, would you like to make an opening statement?
Thank you. No, the letter that we provided will suffice.
As we jump into the questions, I'd like to begin with what value do you see for your department in the what value do you see from the introduction of a territory coordinator for your department?
Yeah, thank you very much. I think from my point of view, the sort of challenges of getting significant mining and energy projects into over the line, past final investment decision and into implementation is working through the sort of significant regulatory processes that are required. A number of those are within the remit of the Northern Territory Government, others are outside the remit. But from a proponent's point of view, it's a really sort of a complex process to go through. So the second word of territory coordinator is all about that coordination. And I think, it's sort of from a strategic overlay, it provides that bespoke service to walk through this difficult and complex environment. I think that these are the things, if you see things from a proponent's point of view, in a time frame that, and we really are in a competitive time frame to get projects over the line, we need to try and work with proponents to get them through the various regulatory requirements as best possible. So from my point of view, our responsibilities lie in as priorities of government getting mining and energy projects over the line, and this bill will add value to that.
Do you have any examples of where, if the territory coordinator did exist in the past, say in the past 10 years, where it would have made a difference on a project in the Northern Territory?
I think I won't name proponents as individual projects, but certainly I know of mining projects that have had difficulties working through the regulatory process. Not all of that's government's fault. I totally admit that. Proponents have certainly got a responsibility to do their due diligence, provide their information in a timely and complete manner. But the sort of interplay between the different regulatory requirements and proponents working through that, yes, there have been examples. I think a second more strategic...
What are those examples, though?
So, member for Gwoja, I won't go to individual projects because they're stock exchange listed.
No, I'm not. I'm asking as an overview. Everyone has spoken about examples, yet when asked, can't say if it's a result of environmental, if it's a result of consultation or with landowners. So what are these areas of regulatory process that are stalling?
So within my area, which is the area that I can speak for now, we're pretty confident that our current timelines are pretty good. We don't always achieve the outcomes that we like, and back to my sort of words before, some of that's within our remit, some of that's on the I suppose behalf of the proponents. but there have been issues of working through. If I could go to mining management plans as an example, and getting clarity through those now, the environment is shifting. When I say the environment, the way machinery of government is shifting, and some of that stuff might be worked out, but they are examples of the past, yes. But sorry.
No.
I was going to go back to your question, Deputy Chair. The second example that I'd like to give is probably more a strategic example of a really complex project, and that's the Middle Arm Sustainable Development Precinct. So that is really complex. It's all about establishing a precinct for a range of, I suppose, interconnected and related industries with a long-term vision. And that's a really difficult and complex set of amount of work that has to happen. There's environmental components, there's logistical components, there's infrastructure components, there's commercial components, and I guess we've had the agencies that have been working on that have really applied themselves. I really can't underpin that more strongly, but it hasn't had that strategic overlay. It's sort of been run with a number of different agencies doing their job, but without a coordinated and strategic approach.
But doesn't this model that you're just talking about remove all the ability for relevant organisations with relevant qualification and experience and give them to a single individual who's not qualified in a number of those areas?
So my understanding of the bill as it stands, and I might be wrong, but I'm pretty sure that we still deliver within our regulatory obligations. So for us, our legislation, we deliver on that. The bill allows for prioritisation, but that's still through the minister or through a minister. Those processes aren't fettered. So my understanding of the bill is that no, the current regulatory provisions still apply.
But you acknowledge that the position, not talking about the individual, the position of the territory coordinator can override decisions or recommendations that have been made by an expert group of public servants.
So the point I was making is that the position provides a coordination. So with regards to Middle Arm, a coordination of all the different.
But still, they become the decision maker.
Not necessarily.
How so?
And well, firstly, is my understanding is that the decisions are still made by the relevant minister, the Minister for the Office of Territory Coordinator.
Mr. Member Drysdale. Sorry.
Could I ask a follow-up question to that?
Yep.
Thank you. Just in relation to that and regulations, as the CEO of the agency, you obviously have duties and responsibilities under the acts and regulations. So I'm wondering about how you'll discharge them if the Territory Controller does use a request power, as you've just said, for example, a prioritisation request that causes you to change your way of working. So I can give you an example of where that potentially could happen. For a decision on an environment management plan under the Petroleum Environment Regulations, the Minister must make a decision within 90 days after submission. So how would you, as the agency head supporting the Minister, ensure the decisions are made in that time frame if a prioritisation request means you have to focus your department's attention fully on another statutory process? And particularly, what work processes might you need to change within the department to accommodate that?
So that specific example, an environmental management plan, would not sit within our remit. Right. That would be a matter for the Department of Lands, Planning and Environment. Yeah. But our regulation, our legislation still applies. Okay. For the example that you gave, if that was something from within the responsibilities that the Department of Mining and Energy administers, that legislative requirement still applies. I'll just seek any extra input.
James Pratt, Senior Executive Director, Energy Development. So departments have statutory timeframes to approve matters in, and our prime objective is to complete those in that time. Your question was about how the Chief Executive would reprioritise resources. So if, as I said, the primary focus is to complete all statutory decisions within timeframes. If something's falling behind or running amiss, that reprioritisation can ensure that that gets the priority through the coordinator and the CE having that discussion. It's no different now that when we talk to proponents and we talk to our chief executives, if they want something prioritised, it occurs.
So do you see any additional resource implications for your department from this bill?
It's a good question. Sorry, Alister, Chief Executive, Department of Mining and Energy. It's a good question. The short answer is no. I think the projects are the projects. This is about coordination and a strategic overlay of applying ourselves to projects as they come through and in the order of the priorities of the government. So that'd be my answer. Yes.
Okay, thank you.
Member for Drysdale.
Thank you. Through you, Mr. Chair, I'd like that my questions remain uninterrupted for answers as well. We've heard a lot about the insertion of executive powers throughout this. I was just wondering if I'd open the floor for your thoughts on those.
So my understanding, and I have sought advice on this, is that the executive powers still remain as with the minister. So it could well be our minister, and there is an avenue to go to the minister for the Office of Territory Coordinator. That the executive powers, as I understand it, still remain with ministers.
And the complex process that currently exists, could you talk the committee through what that actually looks like? And if we were to give just a really simple example, if I were a landowner and there's potentially a mineral deposit on my land, what does the process look like at the moment that a company would have to go through?
So I'll just put James on notice that I'll be going to him in a second.
Yep.
But I think the range of things that would have to happen, in your example, a mining project, and I might go to Brett as well, is firstly there's obligations within the department. So the first thing is tenure, and that's probably the most important thing that we look at, because tenure is the contractual right between the proponent and the Crown as the owner of the resource. Then there's activity approvals, and those activity approvals are based on a few things, very importantly the environment, and getting an environmental approval to ensure that the activity that is planned happens in a way that minimises the impost on the environment.
And if I may, just could you elaborate on that part there? What's that kind of process look like, the environmental?
I might just go to Brett if I could.
Yeah,
because
absolutely.
Brett Easton, Director of Policy and Reform, Mining and Energy.
Can you please just hit the button on your microphone? Sorry. Thank you.
Sorry, everybody. So as far as the stages of getting a mining proposal approved and operational, and it really is staged because it starts with exploration, and exploration is usually the first window of opportunity for consultation with affected parties. And so as that process plays through, and that can be somewhat time consuming in some instances, then and then it's down to the company to try and secure or identify that resource, and then to assess whether that's actually going to be worth the investment. And I think highlighting what Alister said earlier is there's so many other elements that are then involved. So infrastructure, for instance, so the quality of the road to allow for haulage, the connection to power supply, water availability. And so once you start introducing all of those other elements, you really are involving a lot of agencies and a lot of different processes. So it does, I think, have an opportunity there to, bring that together in a way that perhaps individual agencies are not so much focused on. Ultimately, once a company has developed their plan, then that goes through the environmental assessment process.
Member for Johnston.
Oh, sorry. If we can continue from where we were at with environment.
Yeah. So the environmental approval, there's also on top of that, depending on what activity is, there's an assessment around the operational plans. So there's a strong tie-in with the environment. Building on Brett's stuff, there can be sort of broader infrastructure approvals required. For example, if you from a access point of view, road access, intersections, that sort of thing, corridors. There are probably more, but that gives a flavour.
And final question. In the view of the department, do you see the territory coordinator as, I guess, a step forward in building investor confidence and the economic impact that will bring?
The short answer is yes, and if I could build on that answer, I think one of the things that we've benefited from is we've had the ability to go right around Australia and look at similar models right around Australia and how they work in each of those jurisdictions. Some have been in place for a long time, for example, Queensland, and they've learned a few lessons along the way, I guess. Our context is different, so we need to understand that. I think the value of the coordinator model is around that sort of integrated and strategic approach to project development. Investor confidence is really about sovereign risk, so having goalposts in the ground that don't shift, and timeliness and accurate information. So if we've got good, strong legislation, which I would contest that we do, we have, I suppose, a really what's the right word? Agile approach to working through the legislative process in a coordinated approach, and there's confidence in both of those processes. That really builds in bringing investor confidence in, and we've got a lot of opportunity with our resources, but we're a small community and a small government. So we really need to look to be innovative, to be competitive in a broader investment environment.
Thank you.
Member Johnston.
Thank you. And I appreciate you sharing that you've looked at this similar legislation in other states and territories or states, and we've heard about that as well, and have been made aware that this particular piece of legislation goes a lot further in terms of models in other states and territories, and people have concerns about that. I'll just put that aside for a minute. I just wanted to ask a specific question that, as I'm sure you're aware, previous Clause 14 in the original exposure draft of the bill prevented the Territory Coordinator from exercising the powers under the Act in a manner that it would interfere or modify with the protection of sacred sites. I won't read the whole part of it. I'm curious about whether your agency recommended that protection be removed.
My understanding, I could be corrected, but we didn't enter into that discussion.
Okay, right, thank you.
Perhaps following on from the member for Johnston's question, are you prepared to take that on notice so that we have an understanding if that did or didn't occur?
Yeah, absolutely. We'll take that on notice.
Going to the member for Johnston's line of questioning, the perspective that other jurisdictions tend to have a panel, Queensland, for instance, their coordinator legislation has a group of individuals who look at and make those assessments. Is the department concerned at all by vesting all that kind of decision making or recommendations to one person, to the minister?
My answer to that, well, the short answer is no, and the reason being a small jurisdiction, our doors are relatively easy to walk through, and we do try to talk with each other. So I think that there's a sort of a natural synergy of a coordinated approach in supporting the territory coordinator, and I'm focusing on the coordination part of the bill. So. I think bigger jurisdictions with more resources might take a different approach, but I think from our point of view, the model that I see, and I from my point of view, going back to your initial question, is I don't have concerns with the way it's put.
And I guess, do you have concerns that there might be some uncertainty created from this piece of legislation around how it intersects with Commonwealth under the EPBC legislation?
Yeah, again, the short answer is no, because I think it's pretty clear that legislation outside of the authority of the Northern Territory is not part of this process.
Right. So just to be clear, you said in your previous remarks that you were happy with the approval timelines within your current department or agency.
I indicated that we're not always perfect, but we do try to meet our timeframes, yes.
Sure. And I just wanted to be clear in that regard. And normally it would be the role or the function of your agency or department to look at the coordination of various proponents coming through, that they're checking the right boxes and making sure that they're doing the due diligence on the government side.
So our role is focused on our responsibilities, but back to my former words, a proponent and a project has a much broader range of responsibilities. So yes, we will focus on delivering our responsibilities, but having that overarching coordination and I suppose, as I think I used the words, bespoke approach to working with proponents as they work through the regulatory matrix. I think that adds a lot of value, particularly back to your point, member for Drysdale, around building investor confidence.
Yeah. And just, I guess, the section, obviously, with the removal of the merits review, there will be potentially the increase in judicial reviews, or the request to have judicial reviews, which we've heard from previous deputations today that can be quite a lengthy process. Are you concerned that will then be the process in which holds up development?
With apologies, member for Gwoja, I can't speculate on that.
You can't
I can't speculate on that. Yeah.
Member for Johnston.
Thank you. We've heard a lot of concerns from people about the consultation process for this bill, about the transparency of it. I'm interested in your thoughts on how we can ensure that there's confidence in this role, and how you'll be monitoring the effectiveness in terms of what you're saying you think this bill will deliver.
Thank you very much, Member for Johnston. I think the important thing, as I understand it, is our consultation processes within our responsibilities do not change.
Okay. Can I just go back to a previous, you were talking earlier about, the idea of improving investor confidence with certainty. And one of the other things that we've heard from many people is that there's a lot of ambiguity and lack of clarity in the Act as it stands, and people are concerned that will actually increase uncertainty. Do you have any thoughts on that?
My understanding of the bill is that it's pretty clear, or at least that's, I must confess I've not read every segment of the bill, but I certainly have been maintaining a fairly close watch as it's developed. I don't see ambiguity that would erode investor confidence, no.
Okay. I think, taking you back, I can't remember if you used the word flexibility or agility or whatever in terms of interpretation of particular requests that might come. So I'm talking about that kind of ambiguity.
Okay, thank you, and I appreciate you bringing that up. I meant that in a different light, and I can understand that my words might have been interpreted in more than one way, but really that agility to look at the administration of our regulation, meet the integrity of the administration of that regulation, but also in the mindset of how that intersects with other agency responsibilities and how we can get that to best be implemented in an overarching sense in a timely manner.
Thank you.
The member for Gwoja.
Yeah, thank you. I've just got a question. Clause 18 of the bill talks about the Territory Coordinator's ability to delegate their powers and functions to any person, as the definition under the Northern Territory Interpretations Act. That being very broad, does the department have concern that the Territory Coordinator could delegate the functions or decision-making to a public servant who has no understanding or technical aspects within the agency to make decisions?
I'm not able to answer that specific question. I'll just...
That's okay. I note that they're behind me so they can answer.
Yeah, thanks.
Yeah.
Thanks, Member.
Any further questions from the committee?
Just thank you. One more. I'm interested in terms of your role. It sounds like you've got very, robust processes that you're happy with, that you'll be continuing on with as part of this. In terms of managing potential conflicts between the new bill and your existing resource laws and stakeholder concerns, including those from Indigenous communities, how do you see they will be addressed under this bill with you implementing?
Could you please just repeat the last bit?
Yeah, sorry.
I'm a little deaf.
No,
I
sorry.
just want to get this correct.
Yeah. The last part was, how will you be addressing or managing stakeholder concerns, including those from Indigenous communities, if there are potential conflicts?
So I don't see that there are conflicts for us in the administration of our responsibilities. We have very defined processes and mechanisms to do that. And so I don't see that there are conflicts in that regard. I think we, to me, I see that we become part of a broader, more coordinated approach to a project development. But our processes and our mechanisms are well defined in the legislation that underpins them.
Okay, so you feel confident that this bill will not affect your ability to manage any of those conflicts into the future?
Yes, the short answer is yes. Okay. Yeah.
And just to follow up from my previous question about the changes between the two bills, did your department recommend the removal of the Heritage Act?
I think that was the question.
Oh, you asked that. Sorry, Chansey.
Yeah, they're going to take it on notice.
Oh, yeah. Sorry.
On behalf of the committee, I'd like to thank you for appearing today and speaking with us. I know you're all very busy, but thank you very much for making the time and answering our questions, and for your submissions. Thank you.
Thank you for the opportunity to appear.
Thanks, gentlemen. Cheers.
Thank you.